Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a significant decision, the Supreme Court affirmed that mere membership of a banned organization makes a person criminal and liable to be prosecuted under the Unlawful Activities Prevention Act UAPA provision. Reversing its own 2011 judgment, the Apex Court held that as bad in law subsequent decision passed by the High Courts pursuant to its two-judge verdict in 2011 on the issue of membership of banned outfits. The Supreme Court upheld Section 10AI and said that all High Court's decisions to the contrary are overruled. It further noted that as stating the Section 10AI is in sync with the objectives of the UAPA Act to protect the sovereignty of the nation. Solicitor General Tushar Mehta thanked the bench for the historical judgment and said that it would protect the sovereignty of India. Similarly, overruling its 2015 judgment, a larger bench of the Supreme Court has fully restored the jurisdiction of the High Courts to hear petitions challenging judgments and orders passed by the Armed Forces Tribunal, which was restricted due to an earlier decision by a division bench of the Apex Court. The judgment comes as a big relief to the defense community, which has been rendered almost remediless in 2015, wherein the AFT practically became the first and last court for them. Till 2015, most litigants agreed by the order of the AFT were challenging them in the jurisdictional high courts of their respective states. However, in 2015, the Supreme Court in the case titled Union of India versus Major General Shri Kant Sharma held that in view of the specific clause of appeals to the Supreme Court provided in the AFT Act, the High Court, though empowered under the Constitution, should not hear challenges to the orders of the AFT. This made defense personnel, pensioners and their family literally remediless, since as per the AFT Act, an appeal to the Supreme Court only lies if a point of law of general public importance comes into play. The Supreme Court has held that where the validity of a community certificate is put in question, keeping in mind the importance of the document and the effect it has on the people's right, the proceeding questioning the document cannot, except in the most exceptional circumstances, be done ex-parte. A division bench of Justice Aniruddha Bose and Justice Krishna Murari opined that the right to pensionary benefits is a constitutional right and such cannot be taken away without proper justification. The appellant was appointed as a clerk cum shroff in respondent bank based on a community certificate and retired as a Scale 3 officer after serving for 38 years. However, 2 days before his superannuation, he received a cessation order on the grounds that his caste certificate was fake and all his retirement benefits, aside the PF, were denied to him. The respondent bank didn't comply to writ orders of the High Court, which resulted in his retirement without realization of his retirement benefits. The court noted that the process of verifying the community certificate must be completed quickly, yet in the present case, there has been an excessive and unexplained delay of 19 years, which is a length of the time that falls outside the ambit of reasonable time. In the backdrop of remarks of the High Court judge during live-streamed bail hearings causing damage to the repute of the parties, the Supreme Court has observed that it is essential for the courts to be extremely cautious while passing adverse remarks against the parties involved and must do so with proper justification, in the right forum and only if it is necessary to meet the ends of justice. A division judge bench of Justice Krishna Murari and Justice Ehsanuddin Ahmullah was adjudicating upon the appeal filed by the aggrieved party seeking expunging of the remarks made during the hearing, which were widely reported in the media and caused injury to the reputation of the appellants. The court noted that bail proceedings, unlike a full criminal trial, are burdened with the task of only forming a prima facie view on the merits of the case, and in such circumstances, when the evidence is not fully analysed, a presumption of innocence is still operational in favour of the accused. The courts must then be extremely cautious in passing adverse remarks against the accused. This becomes especially important in cases where the party against whom the remarks are passed do not have the list in the said proceedings, for such comments, especially if passed by constitutional courts, can cause great injury to the reputation of the parties at the receiving end of such remarks, the court added. The Supreme Court has opined that while deciding an application for anticipatory bail, the focus should be on the prima facie issues, such as some reasonable grounds that would go to show if the accused has committed the offence, or those facts that would reflect the seriousness of the offence. Noting that the Prosecutrix was the only witness in the present case, a division judge bench of Justice A.S. Bopanna and Justice Hema Kohli ruled that it becomes more necessary for the High Court to have attended to the appellant in a case of this sort when there is typically only the appellant as a witness. Also, such an approach tantamounts to failure to recognize the right of the prosecutrix to participate in the criminal proceedings that would include a right to oppose the anticipatory bail moved by the accused. The court observed that the self-imposed limitation on conducting a thorough study of the evidence at the point of is justified for two reasons: to avoid any prejudice to the case put up by the prosecution or the defense and the accused is likely to take, and to maintain all the aspects upon until the trial is concluded. A Supreme Court Division Bench has delivered a split verdict on the issue as to whether review of a judgment delivered relying on a precedent that was later overruled should be allowed or not. While Justice M.R. Shah, while allowing the review petition, opined that subsequent overruling can be a ground for review, Justice B.V. Nagarathna disagreed and took a divergent view. She observed that the petitions are not maintainable as per Order 47 Rule 1 Code of Civil Procedure bars the same. She was of the view that though the power to review is conferred by the Constitution and is therefore a constitutional power, the power is circumscribed by the CPC and SC Rules 2013, stating that the scope and power to review a judgment or order by the Supreme Court is restricted to the contours of Order 47 Rule 1 CPC. She reiterated the fact that Rule 1 of Order 47 of the SC Rules 2013 made the virtue of Article 145 states that in any civil case, review lies on any of the grounds stated under Order 47 Rule 1 CPC. Next we have Delhi High Court. The Delhi High Court has allowed the petition of a law officer working full-time with the public sector undertaking seeking the inclusion of his name in the final list of the Delhi Higher Judicial Services 2022 examination. The Division Judge Bench of Justice Nazmi Waziri and Justice Vikas Mahajan observed that the petitioner advocate is covered by the expression continuously practicing advocate for not less than 7 years preceding receipt of applications, which is a mandatory qualification for selection to the DHJS. The court opined that the remarks column showing the petitioner only as the law officer of his employer cannot be a ground for rejection of his experience in litigation and proof of continuously practicing as an advocate, because he could not have mentioned or described his position as anything other than a law officer, albeit he was acting and or pleading on behalf of the employer as an advocate, and in fact not mentioning himself as a law officer for sale could well raise an issue of incorrect information or misrepresentation. Noting that the predominant function of a law officer of sale is to act or plead and perform functions which only other advocates would perform in relation to court cases, including drafting of contracts and pleading, filing of cases, pleadings and monitoring their progress, attending conferences with lawyers including senior advocates, rendering legal opinions, etc. The court was of the view that the duties and functions with sale encompassed all the lawyers would do in his normal course of practice of law. The Delhi High Court has refused to interfere with the suspension order of a judicial officer who was accused of having accepted a hotel booking from an unknown person for allegedly taking a trip abroad. A division judge bench of Justice Manmohan Singh and Justice Saurabh Banerjee, without getting into the merits of the case, remarked that it was unbecoming of a judicial officer, especially when he is officiating as such, noting that there was a preponderance of probabilities that led the officer to hold the petitioner guilty of the articles of charges and grant him punishment commensurate thereto. The court stated that the perusal of the record reveals that the petitioner was found lacking in giving a material response to the repeated queries put by the High Court since the very inception, and there was too many negatives which unfortunately do not add up to make a positive. The Delhi High Court has directed aviation regulator DGCA to form an appellate committee that will hear the appeal of Shankar Mishra, who is accused of urinating on a woman on board an Air India flight against the 4-month flying ban slapped on him. Justice Pratibha M. Singh said that the committee shall be formed in 2 weeks and permitted Mishra to file an appeal before the panel within 2 weeks. Now let's have an overview of other high courts. The Karnataka High Court has held that a stepmother can claim maintenance from legal heirs of her deceased husband provided she proves by way of evidence that her husband was in possession of a substantial number of properties and they were extracting income from them. The single judge bench of Justice K. Natarajan in this view partly allowed a petition filed by stepchildren seeking to set aside and modify the order passed by the family court granting 25,000 per month maintenance to their stepmother. The court observed that the petitioner's stepmother is entitled for Rs 10,000 per month until the disposal of the case of the trial court in terms of Section 9(1)(2) of the Senior Citizens Act, wherein the maximum limit for granting maintenance is Rs 10,000, and as per Section 2D of the definition, in the said act, parents means father or mother, whether biological, adoptive or stepfather or stepmother, as in the case may be whether or not the father or mother of the senior citizen. The Punjab and Haryana High Court, in a petition challenging an order related to domestic violence, Justice noted that the objectives behind the Domestic Violence Act 2005 as to how it is important to safeguard the women because domestic violence is still prevalent in society even after an increase in the education and understanding of the human relationships. The court observed that the objectives of the act is to protect a wife or a female living partner from the violence at the hands of the husband or male living partner or their relatives, and the law also extends to protect the women who are sisters, widows or mothers. It was thus ruled that the definition under section 2A, F, Q and S are to be read and understood with section 19 of the DV Act, whereby the magistrate can pass a residence order on being satisfied that the domestic violence has taken place, and such orders would become toothless unless relative including family relatives are also bound by it. The court then referred to the judgment of the Supreme Court in Hiral P. Harsora and others versus Kusum Narottam Das Harsora and others, whereby the words adult male was struck down from section 2Q of the DV Act. The Orissa High Court has stated that if during a tussle caste name is taken suddenly in context of abuse, it will not attract an offence under the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 unless it is prima facie established that there was an intention to humiliate or insult the victim for their caste or tribe identity. The court observed that the alleged abuse hurled at the witness in which the caste name was mentioned was a spontaneous incident and not intended to insult or humiliate the witness or commit any offence under the Special Act. The Madras High Court, while dealing with the legal question of as to whether mortgage deed would amount to a usufructory mortgage or not, whether Article 137 of the Limitation Act would apply on usufructory mortgages' right to a final decree application or not, Justice Vijay Kumar answered in negative. Relying on the Supreme Court judgment in the case of Singh Ram through their legal representative versus Shio Ram and others, and pursuing Section 62 of the Transfers of Properties Act, the court held that the right of the usufructory mortgage to recover possession commences only when the mortgage money is paid to the rents and profits or partly out of the rents and profits and partly by payment or deposit by the mortgager. Until then, the limitation does not start for the purpose of Article 61 of the Schedule of the Limitation Act. Therefore, the usufructory mortgage's right to final decree application is not governed by Article 137 of the Limitation Act. Thus, it is clear that the right of the usufructory mortgager to redeem the property does not get extinguished due to the non-application of the mortgager money within the time fixed by the court. The Gujarat High Court has dismissed the petition seeking direction to the respondent to remove or demolish illegal encroachment in Gujarat Housing Board and held that unless the petitioner specifies particular illegal encroachment, the plea for demolition will not be maintainable. The court noted that if petitioners prefer petition as aggrieved persons, in that case it was expected from them that to specify particular encroachment for which they are seeking demolition. The Allahabad High Court has held that anticipatory bail under Section 438 CRPC can be sought by a person if he has a reasonable belief that he may be arrested even though the FIR regarding the alleged known bailable offence is not yet registered against him. The single judge bench of Justice Nalin Kumar Srivastava, however, clarified that the law does not permit knocking at the door of the court for the grant of anticipatory bail on merely vague assertions in the absence of any relevant material, and certainly the court will not grant anticipatory bail in such a case. Moving on to miscellaneous news. The Department-related Parliamentary Standing Committee on Home Affairs in its 146th report had recommended that there is a need for a comprehensive review of the criminal justice system of the country. Earlier, the Parliamentary Standing Committee in its 111th and 128th reports had also stressed upon the need to reform and rationalize the criminal law of the country by introducing a comprehensive legislation in Parliament rather than bringing about piecemeal amendments in respective acts. With a view to make comprehensive changes in the criminal law of the country to provide affordable and speedy justice to all, create a people-centric legal structure, the government has initiated the process for comprehensive amendments to criminal law with Indian Penal Code 1860, the Code of Criminal Procedure 1973 and the Indian Evidence Act 1872 in consultation with the stakeholders. Not every system is perfect, but this is the best system available, Chief Justice D.Y. Chandrachud has said while defending the collegium system of judges appointing judges, a major bone of the contention between the government and the judiciary. Speaking at the India Today Conclave 2023, the CJI said judiciary has to be protected from outside influence if it has to be independent. The CJI also responded to Law Minister Kiren Rijiju's voicing displeasure over the Supreme Court collegium revealing the government's reason for not approving the names recommended by it for appointment of judges of constitutional courts. He said that the law minister has a different perspective and he is entitled to have one. The CJI said that he doesn't want to join issues with him. Advocate Padma Lakshmi became the first transgender lawyer in the state of Kerala as she enrolled for the Bar Council of Kerala. This even caught the attention of the state's law minister, who put up a congratulatory post acknowledging many roadblocks and that someone like her might have faced along her way while journeying in a society that's not very encouraging. The Apex Court, while refusing to accept the centre's sealed cover note about its views on the payment of one rank one pension arrears to ex-service personnel, has said that there is a need to put an end to the sealed cover practice as it is fundamentally contrary to basic process of fair justice and transparency. The Supreme Court has dismissed a PIL seeking framing of norms for registration of every live-in relationship with the centre and termed it as a harebrained idea. A bench headed by CJI D.Y. Chandrachud asked the counsel for petitioner lawyer Mamta Rani if she wanted to foster the security of these people or wanted them to not get into a live-in relationships. In a major event, Rajasthan has become the first state of India to pass Advocates Protection Act, a law aiming to provide protection to advocates in face of adversities arising to them due to professional discourse. This bill aims to prevent offences of assault, grievous hurt, criminal force and criminal intimidation against advocates and damage or loss to their property. The Bar Council of Delhi has moved to the Delhi High Court against a single judge order directing it to furnish details of all the pending complaints against advocates. The council has argued that the order is bad in law as there is no provision allowing interference by way of writ jurisdiction by the High Courts or any other courts, except the Supreme Court in the day-to-day functioning of the bar councils and matter relating to the disciplinary proceedings. It was further argued that as per Advocates Act 1961, state bar councils as well as Bar Council of India are not amenable to the writ jurisdiction of the High Courts. In the end, we have international news. The International Criminal Court has issued an arrest warrant for war crimes for President Vladimir Putin and a second Russian official. The court says Putin bears individual criminal responsibility for the abduction and deportation of Ukrainian children since Russia's full-scale invasion began February last year. The court also issued a warrant for Maria Lvova-Belova, Russia's Commissioner for Children's Rights, who has been the public face of Kremlin-sponsored program in which Ukrainian children and teenagers have been taken to Russia. The court said in a statement that there are reasonable ground to believe that each suspect bears a responsibility for the war crime of unlawful deportation of population and that of unlawful transfer of population from occupied areas of Ukraine to the Russian Federation. The US Supreme Court has ruled unanimously for a deaf student who sued his public school system for providing an inadequate education. The case is significant for other disabled students who allege that they were failed by the school officials. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.